my son. He's my best friend. This is my world. It's my firstborn, my junior.
You shot him 8 times, and there is no excuse or justification for that under any circumstances.
After Martha and Miriam's death, she kept telling me they just were not ready to die.
Between 2016 and 2018, Billy Chemirmir targeted elderly women in Dallas and Collin counties, allegedly posing as a maintenance worker to gain access to their homes in senior living facilities. Prosecutors claimed he stole jewelry and other valuables after their deaths.
This is my mother. Look at her.
Initially, many families believed their loved ones had died of natural causes, but the circumstances surrounding their deaths later raised suspicions.
I was told that she died peacefully in her sleep. She was 83 when you killed her. Even her doctor called me and she said she didn't understand. She just had a physical.
Victims were described as vibrant and healthy before their lives were tragically cut short, leaving their families devastated and searching for answers.
After Martha and Miriam's death, my mom was in a conundrum. She kept telling me they just were not ready to die. They didn't seem ready to die. Well, guess what? They were not ready to die.
During a victim impact hearing, family members confronted Chemirmir, who sat silently throughout their testimonies.
And you cowardly let the devil wrap his fingers around your heart.
They shared emotional accounts of their loss, displaying photos of their loved ones and recounting how his actions shattered their lives.
Do you recognize this picture? This is my mom. The day after I took this picture, you murdered her. This is not the first time we met Billy. Do you remember? Probably not. We shared an elevator at Tradition Prestonwood. I walked in. You're just standing there. Not a button is pressed. You avoided my attempt to make any conversation to figure out what you were doing there. I reported you to management then, feeling very unnerved.
Many expressed anger and frustration while urging Chemirmir to seek forgiveness.
Ask for God's forgiveness. Otherwise, you will just burn in hell forever.
I hope the last thing that you ever see is a pillow over your face like my mother saw.
The hearing also highlighted concerns over the safety of senior living facilities, with families calling for stronger protections to prevent similar tragedies.
I can only imagine you lurking the halls and thinking, how foolish are these negligent people that they are not recording and reporting me, as I have trespassed in this building over 100 times.
In April 2022, Chemirmir was convicted of capital murder in the death of 81-year-old Luthi Harris during a retrial, receiving a life sentence without the possibility of parole. Later that year, in October 2022, he was convicted of a second capital murder for the death of 87-year-old Mary Brooks and sentenced to another life term without parole. Despite being charged in 20 additional cases, Chemirmir's story came to a violent end when he was killed by his cellmate in September 2023. Laura Smither, a girl from Friendswood, went missing in 1997. Her disappearance shook the community, and weeks later, her body was discovered in a pond. For years, William Reese was a suspect in her case, but it wasn't until 2016, when Reese was already facing charges in Oklahoma, that he confessed to her death. During that time, he also led investigators to the remains of 2 other victims, Jessica Kane and Kellyanne Cox, both from the Houston area. In 2021, Reese was sentenced to death in Oklahoma for one of the murders he confessed to committing. Laura's parents attended the sentencing to witness this significant moment, a step toward justice for their daughter and the other victims. Laura's mother shared that, despite the pain, she has chosen to forgive Reese, but being present for the sentencing was an important act of representation for Laura and the other families affected.
I'm glad we went. I'm glad Bob was able to come this time, and we're there to represent Laura and Jessica as well.
In 2022, Reese pleaded guilty to the murders of Laura Smither, Jessica Kane, and Kelly Cox in Texas, receiving life sentences for each. Although he remains on death row in Oklahoma following his conviction for the murder of Tiffany Johnston, he is currently incarcerated at the Allen B. Polunsky unit in Texas. While awaiting execution for his Oklahoma sentence, the families of his victims continue their efforts to honor the memories of their loved ones and find closure through through the justice served. Nestor Hernandez was charged with the capital murder of 2 hospital workers at Dallas Methodist Hospital. The crime occurred during a visit to his girlfriend, who had just given birth. Hernandez became violent after learning that he was not the father, pulling a gun from his pants and attacking his girlfriend. When hospital caseworker Jacqueline Pauqua entered the room to assist, she was tragically shot. Moments later, nurse Annette Flowers was also fatally shot after responding to the commotion.
He showed no remorse, so I have no remorse for him.
During the trial, Hernandez claimed he was under the influence of drugs at the time and did not intend to harm anyone.
I just panicked, you know what I mean? I didn't know what to do. I had just, you know what I'm saying? I had just shot somebody, I guess.
However, the families of the victims rejected his excuses, expressing their anger and disbelief at his actions.
What was the claim? This entire thing happened because how he felt. Okay, great.
Flowers' daughters, who attended the sentencing, delivered powerful victim impact statements, describing the profound pain Hernandez had caused their family.
I'm shocked that he was able to look us in our faces and make eye contact.
Hopefully you suffer a long and drawn-out painful death and face the hell that you have coming.
One of the daughters wore her mother's jacket to honor her memory, while the youngest granddaughter, named after Annette Flowers, was held during the statements.
You couldn't control yourself for 1 hour.
We do wish it was a harsher punishment.
The family expressed a desire for a harsher punishment, but took solace in knowing Hernandez would spend the rest of his life in prison. He was sentenced to life without parole, ensuring he would never leave prison and bringing some measure of justice to the families affected by his actions. In Grand Rapids, Ramon Logan was resentenced for the 2016 death of 39-year-old Kenneth Kirkwood. Logan and his friends approached Kirkwood and his co-worker, who were renovating a house on College Avenue. The situation escalated when Logan, during a confrontation, struck Kirkwood's co-worker and fatally shot Kirkwood.
They didn't have anything to do with this or you. They weren't causing any problems or troubles. You shot him 8 times, and there is no excuse or justification for that under any circumstances.
Logan was originally sentenced in 2018 to 38 to 100 years in prison, with the judge exceeding typical sentencing guidelines due to the severity of the case.
Because of my choices, a man lost his life and our families were forever impacted. I took myself away from my daughter and my family, and I hurt so many other people.
However, the Michigan Court of Appeals later ordered a new sentencing, citing that the judge had not adequately justified the extended sentence. During the resentencing, Logan expressed remorse for his actions, admitting his poor decisions as a boy and acknowledging the pain he caused.
In 2016, I was an immature, drug-abusing teenager with poor judgment and who made bad decisions. I never thought about my actions or how I could hurt other people. Because of my choices, a man lost his life and our families were forever impacted. I took myself away from my daughter and my family, and I hurt so many other people.
He shared that he had made efforts to change during his time in prison and hoped to break the cycle of incarceration within his family.
This is not how I want to live my life. I want to be the good person I know that I am and change the cycle of incarceration in my family.
The defense argued for leniency with claims of his now mature and responsible attitude.
He was 17 at the time. I've seen a progression in him in terms of his maturity and coming to understand what it means to take someone's life and the horror of that. So he is even more remorseful than the first time he was before you.
The judge emphasized that nothing could justify his actions and described him as a heartless, cold-blooded person.
This was clearly a cold-blooded murder.
After reviewing the case, Judge adjusted Logan's minimum sentence from 38 years to 31 years, while emphasizing the seriousness of taking a life and the need for accountability. Logan is now serving a revised sentence of 31 to 100 years, reflecting both the consequences of his actions and his stated efforts toward personal growth. The tragic events began in July of 2022 on West Market Street in Warren, where 20-year-old Dominic Harvey was involved in a shooting that took the life of Jotton Lee Jr. and injured another man. Following the crime, Harvey faced multiple charges, including aggravated murder, aggravated attempted murder, tampering with evidence, and receiving stolen property, as the firearm used in the incident was stolen. During court proceedings, Harvey pleaded guilty to these charges, admitting his role in the fatal shooting. The plea agreement removed the death penalty specification, sparing him a possible death sentence.
I don't think anyone in the state of Ohio should get the death penalty, and I'm really thankful that through this outcome my client was able to avoid it.
It's not justice because I wanted him dead, but I am satisfied for what we got,
In court, he expressed regret, apologizing for his actions, and stating he wished things could have been different.
I'm sorry things went how it went. I wish things could have went differently.
My son is my best friend. That was my world. It's my firstborn, my junior. Personally, I don't think they gave you enough time.
The courtroom was filled with Jotton Lee Jr.'s grieving family, who shared emotional statements about the profound loss they endured. His father described him as his world and best friend, emphasizing the irreplaceable void left by his passing.
I really do hope Dom rot in hell for the rest of his life. I hope his family hurt just as we hurt, and I don't ever want to see him outside of themselves again.
God gonna give him his time because he took somebody very special away from us.
Jotton was remembered as a loving son, grandson, brother, and father who brought joy to those around him.
He will spend the rest of his life in prison, and Mr. Harvey deserves to die in prison, and hopefully that's exactly where he will be.
I love my daddy.
It's just hard to just know that he's gone, but we got some type of justice today, and I'm just grateful for that.
Harvey was sentenced to life in prison with the possibility of parole after 50 to 55 years. He will also be required to register as a violent offender. While the family felt the sentence did not fully match the gravity of their loss, they expressed gratitude for achieving some measure of justice. Walter Ellis, infamously known as the North Side Strangler, was responsible for the deaths of at least 7 women, including Deborah Harris in 1986. Over the span of 2 decades, Ellis evaded justice while continuing his crimes. His case exposed serious flaws in Wisconsin's system for collecting DNA from convicted felons, which allowed him to remain free for years.
Oh my God. He looks like a monster. I can't hardly even stand to look at him.
Patricia Donald, a close friend of one of Walter Ellis's victims, reacted emotionally when shown his most recent prison photo.
I just wondered, did he ever ask God for forgiveness for what he did?
At one point, while incarcerated for a lesser offense, Ellis persuaded another inmate to provide a DNA sample in his place. This deception enabled him to avoid detection, leaving authorities without the crucial evidence needed to link him to the murders. It wasn't until years later that his crimes were uncovered, prompting Wisconsin to reform its DNA collection practices and retrieve samples from hundreds of felons previously missed in the system.
You've never had Walter Ellis's DNA sample on file like it should have been. It would have allowed us to solve the case a lot earlier. Steps were taken immediately to correct that, and those are still ongoing. You still have, hundreds of DNA samples that are still in the process of being collected.
Ellis was eventually convicted and sentenced to multiple life sentences, but he served only 4 years before dying of natural causes while in prison. His death brought mixed emotions, with some close to the victims expressing frustration that he did not spend more time facing the consequences of his actions. Vaughn Cannon was charged with the murder of his wife. Initially pleading not guilty, Cannon later confessed to the murder of his wife, Jordan Pyle, bringing the tragic story to light. The court heard powerful accounts of abuse and violence during the proceedings. Cannon's ex-wife testified about the mistreatment she endured during their marriage, providing insight into his troubling behavior. An investigator from the Oklahoma City Police Department presented key evidence, including body camera footage and excerpts from Jordan's journal. In one one entry, Jordan expressed her inner conflict, writing, "I miss him, not the drunk one, the one I love." Another entry detailed a violent incident, stating, "He pushed me into a mirror." Victim impact statements added to the gravity of the hearing. Cannon's son openly condemned his father, saying, "You are a disgrace. What you did to us is unforgivable." Jordan's father, overcome with emotion, reflected on the loss of his daughter.
Even though we didn't have to go through a trial, there was still a lot of evidence there today that we saw that we were actually hoping we didn't have to see. I noticed some of them got up and went out so that they wouldn't have to see. That's my baby girl.
Throughout the proceedings, Cannon remained mostly silent, often lowering his head and covering his ears as the painful details were shared. In his final statement, he addressed Jordan's family and friends, admitting, "Grief is brutal. I especially failed my beloved wife, Jordan."
I think it was only just that he spend the rest of his life in prison. Take his freedom away from him like he took her life away from her.
In the end, the court sentenced Vaughn Cannon to life in prison without the possibility of parole. The sentencing marked a significant step toward justice for Jordan Pyle and brought a sense of closure to her grieving family and friends. The story began when 25-year-old Alison Sargent was reported missing by her fiancé. 2 days later, the search ended in tragedy when her burned body was discovered near Battle Creek. Investigators uncovered a grim sequence of events. Alison had been killed at a home on Timber Lane, and her body was moved in an attempt to hide the crime. As police dug deeper, a tip led them to surveillance footage showing Alison with Jose Juarez at a grocery store shortly before her disappearance. This discovery opened the door to more evidence. Her car was found burned and abandoned at an Amtrak station in Detroit. Investigators believe Juarez drove the car there, tried to destroy it, and then returned to Battle Creek by train. They also learned he had purchased new carpeting for his home to cover his tracks further.
We have him basically buying carpeting to replace in his home. And, basically there's a very strong case, Your Honor. We'd ask for no bond. Then after killing her, he drove her to Emmett Township where he dumped her body and set it on fire. To supposedly to destroy the evidence of the offense, or maybe to destroy her identity.
Jose Juarez, who had a romantic relationship with Alison, eventually admitted his role in the tragedy. He pleaded guilty to second-degree murder, acknowledging that he accidentally caused her death while handling a gun. In an effort to evade responsibility, he had attempted to destroy evidence. In November 2021, Juarez was sentenced to 27 to 60 years in prison. As part of a plea agreement, additional charges were dismissed, bringing some measure of closure to Alison's grieving family. Ricardo Castillo, a Marine Corps recruiter, has been accused of breaking into a home in Plainfield Township with the alleged intent to harm the family living there. According to investigators, Castillo entered the home during the early hours, removed his shoes to avoid making noise, and retrieved a knife from the kitchen. Inside, he came across two girls who were having a sleepover. During the incident, one of the girls was injured before her friend's father intervened and restrained Castillo until the police arrived. The injured girl was taken to the hospital and is reportedly recovering.
It strikes close to home because they should be innocent. They shouldn't have to worry about stuff like this.
The detective believes that there is a possibility that the door was unlocked, which helped him break in.
It is fairly rare, but I think it's a good point to remind people, check your doors, check your windows, make sure things are locked up.
Authorities claim Castillo admitted to planning the break-in with the intent to harm the family. Earlier that same night, he is believed to have entered another home unlawfully.
This case, it's as scary as it gets. It's as horrific as it gets. And it puts all of us in a fear zone like no other.
He has been charged with several serious offenses, including assault with intent to commit murder, first-degree home invasion, and assault with intent to commit criminal sexual conduct.
Certain places just think they're immune. Certain places think, it can't happen here, but things do happen. Bad things happen anywhere, and we just can't go by, this is, it won't ever happen here because it hasn't for the last 20, 30 years, whatever it may be. Crime can occur anywhere, so it's just prudent to make sure you're taking whatever steps you can to prevent it.
The community is urged to remain cautious and take safety precautions.
$2 million in cash only. That is how serious this court takes all of these charges.
Due to the gravity of the charges, Castillo's bond was set at $2 million in cash. Once recognized for his good conduct and achievements during his military service, Castillo now faces accusations of this troubling act, which prosecutors have described as both random and alarming. Marte Dejan Manning was sentenced for his role in the tragic death of 42-year-old woman in Plainfield Township. The woman passed away after consuming a drug mixture, which was traced back to Manning through cell phone records. Her body was found in the basement of a home on Sunnyside Street, and investigators determined that Manning had supplied the fatal drugs. During the sentencing, Barton's mother and daughter shared emotional statements, describing the immense loss and grief caused by her passing. Judge Mark Trusaw criticized Manning's actions, emphasizing the harm caused not only to Barton's family, but to the broader community.
You have caused an immense amount of pain and sorrow in this family and this poor victim's friend. And for what? For you selling drugs to make a little money? In my opinion, this is no different than you holding a gun to this woman's head and pulling the trigger. You're preying on people's addictions and weaknesses.
The judge noted how Manning exploited vulnerabilities for financial gain, causing irreversible pain and sorrow. Manning was sentenced to 1 year in jail, followed by 5 years of probation. The judge made it clear that any violation of probation could result in a much harsher punishment, underscoring the serious consequences of Manning's actions. The sentencing marked a step toward accountability for the devastating impact on Barton's family and loved ones. Josiah Hugley's criminal history began years before the case that led to his conviction. In 2019, he was involved in a high-speed chase with the Georgia State Patrol while driving a stolen Kia Sportage. When officers attempted to stop him, he initially refused to comply, weaving through traffic in an attempt to escape. The pursuit ended when Trooper William Marsh executed a tactical maneuver, causing Hugley to lose control of the vehicle. Despite this, he attempted to flee on foot but was quickly apprehended. A firearm was later discovered inside the stolen vehicle, raising further concerns about his criminal activities. Trooper Marsh later testified about the incident, detailing the reckless chase, attempted escape, and subsequent arrest.
When APD came across the radio saying they were tracking a stolen vehicle out of DeKalb County that was traveling I-20 eastbound passing Martin Luther King, I responded to their call, let them know that I was going to be heading to them. I turned around and started heading back eastbound. I was able to locate APD as they were exiting the connector ramp heading northbound from I-20 eastbound. I located what they said was a brown stolen Kia Sportage. After passing several APD officers, I located the vehicle. It didn't have its lights on. It made it very noticeable. Once I approached the vehicle in my patrol.
And they didn't have the lights on?
Yes, sir. It was like that daylight saving time, so it's a little dark outside and heavy traffic.
And so you put your blue lights on to pull over that Kia Sportage?
That is correct, yes, sir. And
what did the Kia Sportage do after that?
At that time, the vehicle pulled onto the right shoulder and began to flee from me. I then pursued the vehicle down the right shoulder of the connector ramp heading northbound towards 75 North. Real heavy traffic. The vehicle then darted into the heavy traffic to an attempt to, avoid me.
Did the vehicle hit any other vehicles? Was there anything like that happened?
Yes, sir. So during the pursuit, once we actually got onto 75 North, the vehicle was able to maneuver through heavy traffic all the way over to the HOV lane. Once it got into the HOV lane, it tried to pass a Chevy Tahoe on the left side of it. It struck the rear of that vehicle and it continued on up the HOV lane.
Did you ever see the driver of that Tahoe again?
That is correct, yes, sir. So once the pursuit continued, they took the HOV ramp to Piedmont Avenue. At the top of the ramp, I was able to perform a pit maneuver and stop the vehicle.
Was that driver okay?
Yes, sir.
And the driver of the Kia Sportage, was that Josiah Hugley?
Yes, sir.
What is a pit maneuver?
It's a precision mobilization maneuver, a technique used by certified law enforcement officers to terminate the pursuit.
Is that with you getting in front of the vehicle and stopping it?
No, sir. That would be placing a precise, basically a move to break the traction or have the vehicle lose traction to attempt to slow it down.
Oh, okay. Making some contact to make it slow.
That is correct, yes, sir.
And you're fully trained and do that as a state highway patrolman?
That is correct, yes, sir.
Was the vehicle searched as well?
It was, yes, sir. It was disclosed to me by the officers on scene. And I actually...
Mr. Williams?
Let me rephrase that, Your Honor.
Okay.
Were you able to recover anything?
Yes, sir. So at the end of the pursuit, once I pitted the vehicle, I was able to exit the vehicle. Once I exited the vehicle, there were two subjects in the vehicle. Mr. Hugley was the driver, and then you had a passenger in the vehicle. I was able to get to the house, so I had to kind of wait for them to exit the vehicle because I can't take two on one. Well, once they exited the vehicle, once I passed the car, I could see that there was a weapon on the driver's seat of the vehicle.
And what was that weapon?
I think it was a Mac 9.
And was there a foot pursuit, or were you able to apprehend Mr. Hugley?
It was. So once they both exited the vehicle, I actually pursued the passenger first, pushed him down for a Mr. Hugley, which we ran towards John Portman. He tried to come off the high-rise curve onto the main road where he fell on his face, and then he rolled on his back. And then from there, I drew my taser, gave him commands to surrender, which he did.
And was Mr. Hugley then charged with offenses?
That is correct.
Is it certified?
It is certified, yes.
Despite his arrest and previous encounters with law enforcement, Hugley continued engaging in criminal activities, with authorities linking him to the Nine Trey Bloods, a known street gang. His involvement in crime escalated further in July 2022, when he and David Booker and Miles Collins attempted to steal a Dodge Charger from Bradley Coleman at a Quick Trip gas station in Peachtree Corners, Georgia. As Coleman inflated his tires, Hugley entered his vehicle, but after colliding with another car, his escape was blocked. A confrontation followed, during which Booker brandished a firearm, and in the chaos, Hugley fired a weapon before the group abandoned the carjacking attempt and fled in their rented black Mercedes-Benz. Authorities tracked them down using surveillance footage, license plate readers, and cell phone data, eventually arresting all three men, with Hugley captured by U.S. Marshals after weeks of evasion. Their first trial in 2023 ended in a mistrial, but a 2025 retrial presented surveillance video, forensic DNA, and cell phone records as evidence. Hugley's recorded statement admitted to firing the weapon, though he claimed self-defense, a claim prosecutors refuted, arguing the crime was pre-planned. All three were convicted and sentenced to life in prison without parole, with an additional 145 years for other offenses. Jewel Jones had made a mistake, one that would cost him dearly. After a past incident of drunken driving, he had been given a chance to prove himself through probation. But now, he stood in court once again, facing the consequences of his choices.
And once again, charged you violated probation by that that you failed to refrain from the use of alcohol and tested positive during an ETG at the James testing facility on June 1, 2022. You found to be a violator, you can sentence to serve up to 2 years. Internal contested probation violation hearing in your counsel. You plead guilty, you will be given a right to a contestant. You understand all that?
Yes, Your Honor.
And you acknowledge that I've thoroughly given you advice and rights and you signed the form.
Yes, Your Honor.
Earlier on this record, you don't need to be repeated, do you?
No, Your Honor.
All right, very good. How do you wish to plead to the fact that you violated probation on June 1, 2022, and that you failed to refrain from use of alcohol and tested positive during the ETG?
I'm responsible, Your Honor.
Is that guilty or not guilty?
Guilty, Your Honor.
All right. The court does find, so it's true that you did consume alcohol on or about 6/1/2022. That was in violation of your probation, and you violated probation based on the consumption of alcohol and positive test, correct?
Yes, Your Honor.
Right. I do find there's a factual basis for the plea. The court accepts saying, with respect to sentencing, we were convicted of operating intoxicated, which is a 3-month offense, and reckless driving, which is a 3-month offense.
It all started when he tested positive for alcohol, a clear violation of his probation terms. Knowing what this meant, he checked himself into a rehabilitation center, hoping to take responsibility before the court could decide his fate. When the judge questioned him, Jones admitted to drinking, explaining that he had been struggling with the grief of losing his grandmother. That moment of weakness had led him back to alcohol, but he had taken action. He had voluntarily entered a 29-day treatment program.
Yes, Judge, the guidelines are correct. All I would say as a way of explanation, not excuse, that he had lost his grandmother earlier that morning, and that caused him to get depressed and make a bad decision, and then he went and got tested on June 1st. Obviously, as soon as we found out of the positive results, he checked himself in the share house for a 29-day program, and he's been there and doing well. You received a letter with the type of treatment he's receiving there. So he took responsibility for it, made a bad decision, took responsibility for it, and tried to get treatment himself so he could come to court today and show that he was proactive in dealing with this issue and the violation. We just asked the court to adopt a recommendation of probation to allow him to finish this inpatient program. He's due to be released July 6th, and then continue with outpatient programming on a regular basis, however the court sees fit.
His lawyer pleaded with the court, emphasizing that Jones was not trying to run from his mistakes. He had accepted responsibility and was actively working on his recovery. They asked the judge to allow him to finish his treatment and continue outpatient care.
Your Honor, I just apologize. I did make a really poor decision. And, you know, I do appreciate Share House, though. When I got there, we definitely uncovered a few things that, like Ms. Nolan said, it was just an explanation, but not much of an excuse, you know, the reason why I did take a drink. And so I do appreciate the treatment I've been in. I've been having a great time, learned a lot, not only about the program, but also about myself. So just looking to put this behind me and move forward.
But the prosecutor wasn't convinced. To them, this wasn't just one mistake, it was a pattern. Jones had violated the terms of his bond 3 times before this. He had been given opportunities to prove himself, yet here he was again. The prosecutor pointed out that Jones wasn't just any citizen, he was a lawmaker, someone who was supposed to set an example. Instead, he had created a dangerous situation on the road and had continued to break the rules.
Your Honor, it's people's position that Mr. Jones should not have the benefit of his HYTA any longer based on his actions. This is the 4th violation that he's had during the pendency of this case. First probation violation to this court. He had 3 bond violations in Judge Bain's court, 1 for drinking. This is an alcohol-infused offense. Mr. Jones created a very dangerous situation on the side of the highway where he was challenging the very people that he should be supporting in this case. These were law enforcement officers. He is a lawmaker in this state. He is asking the court to continue to invoke the benefit of HYTA to him, even though he is not living up to his end of the bargain. This was a very favorable plea agreement that was struck between the parties. Mr. Jones has every reason to be motivated to continue to follow the rules and do what he's supposed to do. His very job is to create those rules, and he's here basically thumbing the nose of the court's order. I've heard this court say multiple times that the purpose of a sentencing is not only to deter future criminal behavior on this client, but also to set an example for society and deter others from committing similar situations. Allowing Mr. Jones to stay on YTA does not send that message, Your Honor. I would ask the court to revoke his HYTA status at this time. Allow him to earn it back. If he finishes his probation with no other violations, then reinstate it. I have no problem with that. I'm not asking for jail for Mr. Jones. I'm not asking for anything, but for him to have to live up to the bargain that he struck. Thank you.
The prosecution argued that he should lose his youthful trainee status, HYTA, HYTA, a special program that could have wiped the offense from his record if he completed probation successfully. They believed he hadn't earned that privilege. The judge listened carefully. He acknowledged that Jones had followed some of the court's instructions in the past, but agreed that this relapse showed a deeper problem. Maybe Jones hadn't fully understood the extent of his alcohol issue until now. The judge told him that while he appreciated the steps he was taking, there still had to be consequences.
YTA, Home Youth Training Act, was put in place to be able to let young people get an opportunity to work through their troubles, and if they show proper trajectory of law-abiding citizenship, that their records would not be marred with a conviction. Since I've sentenced Mr. Jones, been doing what I wanted you to do, done what I've asked you to do. You got to stumble with this matter, brings you before the court today, and unfortunately, maybe it took the death of your grandmother to get you to realize that your alcohol problem is greater than what you realize, regardless of other people trying to convince you that there was an alcohol problem. I don't think you were convinced yourself. I think you might have been thinking that literature saw trying to put you through some hoops without trying to correct an issue that may have been there. Maybe that's a message from your grandmother that you got when you got in the share house. And I'm going to try to give you incentive to stay on that path. You know, you're basically making things harder than what they needed to be. All you have to do is do what you were supposed to do in the beginning, is follow the rules, and you wouldn't be here today. But you take an active role to get this done, and I think this might work and get you on the path of sobriety. If you're in Livingston County, I'd have you in Livingston County Drug Treatment Court. There's no doubt in my mind that that's what you're a candidate for. But with you being in Wayne County, our rules have it that you have to be a resident of our county to be in drug court. It's an intensive treatment. We meet twice a month with this court. We go to 8 AA meetings or self-help meetings a month. We go to counseling 4 times a month, and it's pretty intense, but we've got a really good success rate. You're going to have to, and sometimes I'm facing treatment ahead of time, and that's what you're doing now. That's what I think is appropriate here. I'm going to send you to 30 days, Livingston County Jail. I'm going to give you credit for day-to-day credit for what you're doing over in Shire House right now. And when you leave there, you march yourself right over to Livingston County Jail.
Jones was sentenced to 30 days in jail. However, the judge allowed the time he spent in rehab to count toward that sentence, meaning that once he completed the program, he would have to report straight to county jail. Before concluding, the judge reminded Jones that he had the potential and that alcohol was holding him back from becoming the person he was meant to be. If he truly wanted to change, this was his opportunity. The court's decision was final. Jones had to finish his rehabilitation, serve his time, and prove that he was serious about turning his life around. The defendant appeared in court, facing serious charges of aggravated assault of a child. He assaulted his own daughter. Judge Boyd presided over the proceedings, carefully reviewing the plea agreement negotiated between the prosecution and defense. The proposed deal included 15 years in prison, permanent registration as a sex offender, and deportation upon release.
State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding on count 3 and waiving counts 1 and 2.
Any objections?
No, Your Honor. Yes.
Did you understand you're charged with the offense of aggravated sexual assault of a child? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years in prison and life and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor. Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pre. State, any evidence to support the defendant's plea?
I know we offer State's Exhibit number 1 and all attachments.
Okay.
showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty.
What he has pled to is a single count of a single time of assault of a child, which is aggravated sexual assault of a child. He has agreed to do this early on in his process. He is not contesting his guilt, and he is not contesting what's going on. He's agreed to go to prison, and 15 years is a substantial amount of time.
As the hearing progressed, the defense attorney acknowledged the defendant's troubled past, attributing his actions to personal trauma. However, the judge remained unconvinced, repeatedly challenging his shifting explanations. The defendant alternated between denying responsibility and providing justifications, none of which satisfied the court.
The child is very young. She's in therapy right now. I discussed it with the mother, and this is. There is a desire to get closure early on in this case, Your Honor.
So
at this point, we haven't had to
penetration, but from reading this.
He didn't say that. I said it because I was just talking about the legal issues with that. So,
but I mean, having a child having her brother lick his butt.
That was something that I think was determined that did not happen.
Well, she says that he asked her to lick his butt.
That's a different one. Yes.
What is wrong with you?
Well, Your Honor, I'm not trying to beat around the bush. She was showing me her crotch, and
you got turned on.
No, I didn't. I'm telling you, I'm not physically well, I did get turned on, but not. Well, after a while, she just kept doing that. Tell her not. You know what I mean?
You're blaming a 6-year-old?
I'm not blaming my 6-year-old.
My client was sexually abused when he was a child. Offender, almost certainly be deported. He'll never live. He's been in this country since he was 2 years old. He will never live in this country again. Legally, and he will.
So he's being released after he does his time, released to go somewhere else and deal with his trauma that may result in him molesting some other child.
Well, he has what he is hoping to do is, as you know, the TDCJ system offers a pretty comprehensive sex offender counseling and treatment, and of course, he will at some point be wanting to go on parole. He knows that he's going to have to complete that. To do that, we have talked about it, explained it. He's going to take the opportunity to do that, as well as other programs that are offered in TDCJ. He is motivated to do that, and at some point when he is released, as I said, he's going to go to a country that he has basically never lived in his entire life. What
country would that be?
Mexico.
They have nice beaches there.
I try not to hurt her.
Wait, are you saying that you were molesting her, and as you were molesting her, you were molesting her in such a way because you didn't want her to hurt her?
His attempt to downplay the severity of his actions only raised further concerns about his willingness to accept accountability. They argued that the case had already placed a heavy emotional burden on the victim and their family. They stressed the importance of bringing closure quickly, avoiding a lengthy trial that would force them to relive the trauma.
And at this point, we're asking for this because we have agreed early on not to leave this on a docket, not to go through the process, not to have his daughter have to come in and, as the prosecutor said, be traumatized by this, and he's going to lose his freedom for up to 15 years and for a minimum of 7.5. But as the court knows, parole doesn't happen like that for these cases. They're doing 75, 85% of their time. And so he's lost his freedom for more than a decade. He has done a horrible thing, and there's nothing that he can say right now that can explain that. I think the court's questions of him, how he has confessed to you now that he has done it. And
No, he pled no contest.
He pled no contest because I advised it because there's a civil case going on, but that's a legal advice that he was getting from his lawyer.
I understand, but he pled no contest. So again, we're back to what were you thinking? Because I'm trying to figure out where you're coming from to figure out whether I should follow this plea or not.
Sorry, Your Honor, I didn't do it. I didn't do it to like hurt my daughter. I tried, I'm begging and telling you, please. I'm telling you, please.
However, Judge Boyd was not persuaded that the plea deal was sufficient given the gravity of the crime. Instead, the judge proposed a 20-year sentence, emphasizing the seriousness of the offense and its long-lasting impact on the victim.
He did not tell the police officers it was accidental. I don't think that he's trying to communicate that to the court. All of those things that we have for people who are charged and people who are convicted of this, all of those things we're doing here. He's going to the penitentiary. He's going to be a registered sex offender for the rest of his life. All of those things are what's happening in this situation for people who have this apparent or this abhorrent behavior. He's obviously injured this child, and he understands that. He's signing for 15 years to go to prison because of what he's done.
All right. So this is a life case, honestly. So State, you want to explain to me why the court should follow this 15 years?
Your Honor, this was done, having been in this position, I have seen these cases that languish for 4, 5, 6 years. And I had discussion with the mother, and the benefit of the child was to get this done, have no right to appeal, so the child could move on.
If y'all want to reconfer on that, you can.
Okay.
All right.
Your Honor, two things. I'm set in jury trial in County Court 13. They're starting to pick the jury now.
Oh, tell them you're in felony court. I'll call County Court 13.
It's Judge Skinner. It's County Court 13 impact.
I'll call them. So if you all want to confer and see if he's willing to accept 20 years.
I can't talk to my client about something like this in the matter of a few minutes. I mean, this is something that we just asked for a reset. If that's what the court is asking us to do, it puts too much pressure on the attorney-client relationship for me to talk to him in the box about a complete reworking of this plea bargain. I spent hours with him in the jail, going over discovery, doing all this stuff, and this is. I'm asking for a new setting.
All right, Ms. Ferguson, recall this for tomorrow. Okay.
On this case, Judge, the last we were here, the court declined to follow the plea, offered the client 20 years. We are respectfully, we have given the court reporter payment for the record, and we are going to respectfully file a motion to disqualify the court in this proceeding.
Okay.
So
is your client not accepting the 20 years?
My client is not accepting the 20 years as it's been offered by the court.
All right. Ms. Ferguson, can you put this on the jury trial docket, please?
Your Honor, I've been informed that it will take 4 days for the record, including this one. And so,
whatever date, the first date of jury trial, that's the date of jury trial.
Understood.
Okay.
Thank you.
First jury trial available for this case.
We wanted to respectfully inform the court that if our intent is to file a motion to disqualify the court from this proceeding, and that at this time, the court's offer of 20 years to the client is rejecting because
The defense team rejected the counteroffer, arguing that an extended sentence would not alter the defendant's eventual deportation. They maintained that he was willing to participate in rehabilitation programs and insisted that additional prison time would not change the final outcome. With no agreement reached, they formally requested a jury trial, effectively nullifying the plea bargain. With negotiations at a standstill, Judge Boyd scheduled the case for trial, ensuring that a jury would ultimately determine the defendant's fate. In late November 2022, 22-year-old Jasmine Pace from Chattanooga, Tennessee, disappeared without a trace after visiting the apartment of her boyfriend, Jason Chen. Her sudden silence, coupled with missing Thanksgiving celebrations, immediately raised concerns among her family. When their repeated attempts to contact her failed, they began searching for clues to her whereabouts. Jasmine's family, desperate for answers, tracked her phone and discovered it had last been active at Chen's apartment. When they arrived at his residence, they found personal belongings, including her driver's license and credit card, still inside. This discovery deepened their suspicions and prompted them to involve the police, urging an official investigation into her disappearance. After initial delays, law enforcement obtained a search warrant for Chen's apartment.
The missing persons investigation quickly became a homicide investigation when, even despite his best efforts to clean it up, Jasmine's blood was everywhere. Jasmine Pace's blood, upon the execution of the search warrant, was located all over Jason Chen's apartment. It was obvious that Jason had tried to clean it up based on the scene. You'll see those photos. You'll see photos of cleaning products, but you're also going to see video of Jason Chen on November 23rd, 2022, buying cleaning products at multiple locations the same day that Jasmine's friends and family stopped hearing from her. You will learn that homicide investigators located Jasmine's body in this suitcase on the side of Sup Creek Road, in part due to Jason's own cell phone location records. They were able to track Jason using those cell phone location records throughout Chattanooga on the day of the 23rd. Walgreens, Walmart, most likely looking for a place to dump her body. But then eventually,
Upon entering, investigators found evidence suggesting a struggle had occurred, despite clear signs that attempts had been made to clean up the scene. Surveillance footage later confirmed that on November 23, 2022, the same day Jasmine went silent, Chen had visited multiple stores to purchase cleaning supplies. As detectives pieced together Chen's movements, cell phone data revealed a crucial lead. It placed him near Suck Creek Road, a remote area outside Chattanooga. Following this digital trail, authorities discovered Jasmine's body inside a suitcase, confirming the family's worst fears. The investigation also revealed that Chen had abandoned Jasmine's car at a separate apartment complex, likely in an attempt to divert attention from his own residence. Further forensic analysis provided even more damning evidence.
he sent text messages to Jasmine's phone to try to create an alibi when she was dead inside of his apartment and he was in possession of her phone. You will hear facts of cover-up. You will learn that police never found Jasmine Pace's phone, but they did find her SIM card. The small chip that goes into the side of our phones to store all of our phone's information, her SIM card was located. Where was it? It was in a glasses case inside of Jason Chen's backpack that was in his possession when he was located by the Chattanooga Police Department. And when you think that you have seen enough evidence that Jason Chen killed Jasmine Pace, you will be convinced that he stuffed her body in this suitcase after placing it in trash bags, because you will hear from a fingerprint expert. The fingerprint expert will tell you that Jason Chen's fingerprints were found on the innermost.
Although Jasmine's phone was never recovered, investigators found her SIM card hidden inside a glasses case in Chen's backpack. This placed her personal data directly in his possession. Additionally, fingerprint analysis linked Chen to a trash bag used in the concealment, further strengthening the prosecution's case. During opening statements, the prosecutor shed light on the physical abuse suffered by the victim.
This is the suitcase in which Jason Chen stuffed the 98-pound body of Jasmine Pace. That's where I'm going to begin the story. Except I want you to remember that as you hear evidence in the next week, that this is not a story like the one that you read in a novel where you have to imagine the appearances of characters. The evidence that you will hear in this case is very real. The evidence will not require that you use your imagination. Jasmine Pace was very real. And Jason Chen really killed her. The suitcase was located in a brushy area just yards from the bank of the Tennessee River and right off of Suck Creek Road. In it was the body of Jasmine Pace, who had been placed in a fetal position inside of 3 black trash bags. Her right ankle was handcuffed to her right wrist. Her left ankle had been shackled to her right arm. Her wounds were extensive. You will hear from Dr. Cogswell, the medical examiner for Hamilton County, who will describe those wounds in great detail. He stabbed her over and over and over again, not 7 times, not 29 times, not 43 times, but 60 stab wounds. One wound, a through and through, from the right side of the neck all the way through the left. Another so deeply penetrated her rib cage that the tip of the knife broke off into her lung. You will see the tip of that knife. The state of Tennessee is required to prove to you 3 elements for first-degree premeditated murder. The first is that Jasmine was intentionally killed. The second is that it was with premeditation. You will hear facts and evidence. You will see photos. You will hear from witnesses that allow you to believe beyond a reasonable doubt that she was intentionally killed and that premeditation was involved.
As the trial unfolded, prosecutors highlighted Chen's attempts to mislead investigators. Evidence showed that he had sent text messages from Jasmine's phone to make it appear she was still alive. Sticky notes recovered from his family home detailed personal information about Jasmine, including aspects of their relationship struggles, suggesting premeditation rather than a spontaneous act. During his defense, Chen's legal team admitted that he had caused Jasmine's death, but argued that it was not intentional. They sought a reduced charge of voluntary manslaughter, claiming he had acted in a moment of emotional distress. However, the prosecution countered with clear forensic evidence and a timeline of Chen's actions that suggested otherwise.
Very top subject there, in respect. With respect to the sentence of the defendant, Jason Chen, on count 1 of presentment 315228, we, the jury, do unanimously find the following statutory aggravating circumstances beyond a reasonable doubt, in that the murder was especially heinous, atrocious, or cruel, and that it involved torture or serious physical abuse beyond that necessary to produce death, and do unanimously agree that the defendant's sentence shall be life imprisonment without the possibility of parole.
After careful deliberation, the jury found Jason Chen guilty of first-degree murder and abuse of a corpse. In January 2025, he was sentenced to life in prison without the possibility of parole. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.